Good morning. This is a time set for oral argument in Alcombrac versus Cicerelli, our case CV130148. As I start and describe how we want to proceed today, let me first ask, we did issue an order approximately a week ago with respect to oral argument with some issues that were intriguing to this court. I want to make sure that Counsel for Appellant Napoli received that. Sir, did you receive that?
I did, Your Honor.
Very well. Counsel?
Yes, Your Honor.
Okay, thank you. I'm delighted to hear that. Each side is allocated 20 minutes for argument. Appellant may reserve a portion of your time if you wish to do so, sir. You'll need to keep track of the time using the podium clock. Out of respect for counsel, again, I'd ask those in attendance to make sure that their cell phones are off so we're not interrupted. We have read the briefs. We've conferenced the case. We provided that order as a result in part of our work in advance of today. We encourage you to keep that in mind as you present oral argument today. Our proceedings are being recorded and will be posted on YouTube, among other things. As you begin your argument accordingly, please state your name and the party that you represent. And with that, let me start with Mr. Breyer.
Good morning to the whole panel. My name is Mark Breyer. I represent Kyle Alcombrac. I feel compelled to take about 30 seconds for fear of what would happen if I don't this morning. And before I get into my discussion, if perhaps the panel can imagine what it's like to generally be a trial lawyer and appear in front of the trial courts and juries, and only once in a while have the opportunity to appear in front of the appellate court, and the work that goes in and knowing every case, and then knowing you have particularly formidable adversaries, and you get ready and you think you're all set, and about 5 minutes before you hit court, a bulb goes off and you realize you forgot to shave. So in case the court were to take that as some sort of disrespect, I hope that instead we'll take it as the fear of and respect for what we're doing here.
I think it is fair to say, speaking on behalf of the panel, we do not take that as a sign of disrespect. So, counsel, I appreciate that.
I probably think your counsel wouldn't.
Well, yes, we'll hear from opposing counsel in a moment, but please continue.
I would like to reserve 5 minutes for appeal. There are 4 points I would like to address to the panel. Obviously, the first thing I'd like to do is answer the questions the panel raised. The second thing I want to do is discuss why we think it's clear there is a duty. Third, I want to address why, since there is a duty, the motion for summary judgment was improper. And finally, I want to address, should the court take it up in its order, what the proper standard for appeal is. What the proper duty is on remand. Starting with point one, the court raised 2 questions. The first question was whether the record contains evidence bearing on Kyle Alcombrac's legal authority to enter the property. The answer is a very clear and definitive yes. And that comes in the index record 104 to 108, which was Exhibit 4 to J.P. Morgan Bank's motion for summary judgment, the Section 9 of the Deed of Trust. And that Deed of Trust says, and I didn't know the proper procedure, so I brought extra copies, but I'm sure the court has everything. But if the court wants them, I have one for counsel and for the court. But to highlight a couple points, what it says is basically once the borrower fails to perform, the lender may do whatever is reasonable, and specifically includes securing the property, which includes but is not limited to entering the property to make repairs, change locks, and then it goes on with other things. So explicitly lays out what Kyle was doing on the property that day. There is a, just so the court knows, something in the appellee's brief that suggested that Kyle Alcombrac is a locksmith. Below, it's not a big issue, but below it was clear he's not a locksmith. He was paid very close to minimum wage and was taught how to basically drill out locks. And he was not a skilled laborer who had done this for a long time. For months he had this job opportunity he had moved across the country for. So in any event, the first answer to the question is there anything in the court record that says there was a right to be there, explicitly right down to changing the locks? The next question the court raised is whether upon borrower's default there's a power to enter the property. I realize to some degree that's been answered, but let me give 3 answers to that. One, a contractual one, second, a legal one, and third, a factual one. The answer by deed or by contract is clearly yes, based upon the index of record 104 to 108. In other words, the deed says as soon as the borrower falls back in default and before the sale, there's a right to enter and change locks. So contractually, the answer is yes. Legally, all I can tell this court is I could not find anything in the law where Arizona law would supersede the contract between the mortgagor and mortgagee. So since there's a contractual right to enter, I cannot imagine without very clear authority to the contrary why there wouldn't be a legal right to enforce that contract. And third, factually.
Let me ask you before you get to
Please.
the factual point, legally, the tenant couldn't then exclude people from the property that he was in possession of?
I can't answer with certainty what would happen if, because I'd have to read the deed, and I've never done banking law, what would happen if Mr. Ciccarelli had contacted the bank and said, I have someone living on that property, you're not allowed in. It's an excellent question that I can't answer.
Well, but let me ask you, who,
Please.
and I forget the tenant's name just now.
Mr. Harrison.
Harrison. So your position suggests to me on the contract and legal, and we haven't gotten to the third
Yes.
yet because I interrupted you, but did Mr. Harrison have any ability to exclude people sent to his property from coming into his home, say at 4 a.m. unannounced? I mean, that seems like a very long road. I mean, that seems like a lot.
It's a fair question as to whether or not, under any circumstance, a renter could say no one's allowed in. I mean, I didn't brief it, and I'm not. So I don't know the answer to that. What I would say, to tie it back into where we are here, is that if there is a question whether or not there was a legal right to be on the property, before we get to the next issue, and that is duty, was there a legal right for the bank to send someone to change the locks once the borrower was in default? It's a clear yes. The question the court's raising is, well, once you have that right, can that right be withdrawn if certain actions are taken? I believe is what the
Well,
court's asking.
my question's a little different. Let's assume that right exists.
Yes.
How does that interact with the tenant's right to presumably not have to allow everybody in the house that he occupies as his dwelling?
Well, I would imagine that there's an implied covenant of good faith and fair dealing in this contract. So I would suggest that if a tenant had somebody come in at 4 a.m. to change the locks on a mortgagee deed, they could argue that was not being done in good faith. Having said
Well,
that,
but the tenant's not a party to this contract. Tenant is a renter, presumably.
Correct.
From the putative landowner.
yes, I think it's clear that that's what the renter is. Could the renter have stopped? I mean, if the owner of the home has a contract that once it falls into default gives the right to enter onto property, it would be, I cannot imagine as I stand here, a way that a renter who doesn't own the home, who's not a property owner under any way, and is not part of the contract, would therefore have a right to stop entrance.
But that's why I waited to interrupt you until you got to your second point,
Please.
because you're talking about what legally is allowed. And don't renters have certain rights to control access to the property of their dwelling under Arizona law, quite apart from what a financing contract might say?
I do not know. I know that the renter clearly has a whole set of codified rights under the Arizona Residential Landlord and Tenant Act, as between the renter and the landlord.
Right.
What can someone in an apartment complex, for instance, or in a home they're renting do to prevent a third party who has a legal right to access to that property? All I could say is it seems to me that it would be unusual that we would give the renter superior rights to the landlord. If the landlord has to give rights for someone to enter the property, it would be, I did not see anything in the law, so I would not attest to this court now that I know the answer to this. But it would be surprising to me that Arizona law has something that I didn't find that would say, of course, I really didn't look for the renter, to be fair.
Although what we might be talking about is the right that I don't want to say a homeowner, but a person has to be safe in his home.
Right.
Which gives rise to all sorts of reasonable response issues that we encounter in the criminal context all the time, and that might get us into the superseding cause argument, which I'm not inviting you to address right now, but that may be where that authority is found.
And I think that there's a reason why Mr. Harrison was never sued, why Mr. Harrison was apportioned either no fault or I don't know if he was apportioned any fault by the jury, I can't remember, some small percentage. In other words, he was never charged. That as to the tenant, who's a renter, who's sitting on his property, and I'm skipping ahead a couple of issues, but since the court raised it, sitting on his property, having no idea anyone has a right to enter and no reason to know why anyone would enter, sitting in their home, and suddenly someone's drilling out the locks to your home.
And that's your point. That's the response to expect unless the tenant is warned.
Right. And so, real quickly, the factual point is only as to the question as to whether or not, in terms of question 2 that the court raised in its order last week to be addressed. We talked about the contractual right to enter and the legal right, which the court has raised. Could there be something I'm missing? There could be, but it would seem odd to me that there would be such a law. But I want to attest to this court that I specifically looked at that issue.
Because the motion papers in the trial court didn't focus on this issue, it's not precisely clear, but I gather there's no dispute that the Ciccarellis were in default, that the home secured a note that was given by the Ciccarellis and they were in default.
It's not disputed only because below there was all kinds of evidence that was never disputed by defendant Ciccarelli or anyone else. I could be, I believe I'm pronouncing that name correctly, Mr. Ciccarelli. Okay. And so that's right. I believe there was all kinds of dispute had the case gone to trial against Mr. Ciccarelli as to whether he expected them to enter the property, which would be a fact question, obviously, but whether he knew he was behind. And as the court papers, the court may have seen from the index of record in some of those papers, I think it was undisputed. He had many homes he owned. He was behind on many of those homes and had told the renters in none of them. But so factually, which leads to the point that there was, in fact, a lot of factual discussion below that what Kyle Alkenbrecht, my client, the plaintiff, was doing was being done by many companies, by the thousands, so to speak, across the valley. So since there's this contractual right, and since we unfortunately in Arizona went through a terrible time and many people were not able to keep up with their mortgage payments, many of these companies were hired and people were given jobs like my client who were previously unskilled and they had the opportunity. In other words, the idea that this is legally, to address perhaps the court's question with the factual point, if there was not a legal right to do this, then it was being violated by the thousands daily. And perhaps that's an exaggeration to say thousands daily, but literally there are these companies.
So even just upon one missed payment, then the lender has the right to come on and secure the property?
I'd have to read the entire deed. In this case, we're not dealing with one missed payment. We were many months behind, and I'd have to literally go back and reread everything to give the court how many months. But this was not a situation where he missed August's payment and in September here comes someone to change the locks. This was a case where he had many homes, stopped paying, and it was months and months and months before they came in. According to the police report, he already knew that there was a sale set up for May, and this happens in March. So for that sale to be set up, and again, going by memory, and it's in the court record, we were many, many, many months into non-payment while still collecting rent before we get to the day of the shooting. And I know I'm going to have to speed up to try to reserve those 5 minutes. So let me, if I can, explain why I think a duty exists very quickly. I think Gibson controls. I think Gibson basically says we have a duty to avoid creating unreasonable conditions. And I just want to point out something the court may know, but perhaps in a more pointed way. Kyle was on the property because the defendant chose not to make mortgage payments. Now, I'm not faulting the defendant for that. It can happen to anyone. But that was the defendant's action of not paying the mortgage payment. Then the defendant failed to make the bank aware that he had a tenant. And that's a disputed question of fact for the purposes of appeal. He failed to make the bank aware. Now, that was his choice again. So the reason Kyle was entering land thinking there was no tenant is because his company thought there was no tenant because you didn't pay your mortgage. So first you made the active decision not to pay, the active decision not to make sure that you inform the bank, I have a renter there. And then, of course, we get to the point at issue. And then the danger is created because you simply don't tell your tenant, presumably, I believe a reasonable jury may find, you didn't tell your tenant that in 2 months he may lose his home, so you keep collecting rents. So
let me ask you the scope of that duty, though. Does that turn on whether the person knows they're in default, whether they know anything about the nature of their tenant, whether they, I mean, you've mentioned several factors, whether they're still getting rent or whether the tenant is a holdover tenant? I mean, does it turn on those things?
In my opinion, no, Your Honor. I think those are all breach issues that help point to the fact that if we were to believe there's no duty here, that would mean that even if Mr. Ciccarelli knew that he had, again, these are all questions of fact, but knew he had someone armed and dangerous, knew someone was going to enter the property to change the locks, knew that this was a dangerous situation, and even if he sat around joking, and there's no suggestion of this, but just to make the point on duty, sat around joking with his wife, boy, I wonder if someone's going to get shot there. If there's either duty or there's not. If there's no duty, then what we're finding as a matter of law is literally this man who made these choices. I mean, we keep talking this in action, or in the appellee's brief, they keep calling it an action of nonfeasance. Well, generally nonfeasance basically means, well, I'm not the one creating the condition. This condition was created entirely by this individual.
Let me ask you, the duty that you're advocating should obtain here, should govern, how would someone in default discharge that duty? What actions would they take?
My belief would be the duty exists, period, regardless of what action you take. If you take certain actions, there would then not be a breach of that duty.
And that's a fair clarification, but what would a landowner have to do
What does it require you to do?
to avoid breach?
I believe it's a question of fact for the jury, but ultimately, because I think the duty exists. Now, realistically, if we were going to say at what point would a court say as a matter of law there was no breach, if the homeowner says to the bank, here's my tenant, and make sure that they know, and says to the tenant, someone may be coming in onto the property because I may lose this home. I still think that would be a question of fact for the jury, but it'd be a much more difficult jury question than we have here.
So the complaint alleges that the breach was only failing to inform the tenant that the loan was in foreclosure. You believe that at trial you could also ask the jury to find that a breach occurred by the defendant's failure to let the bank know that it was occupied.
I believe the main breach that a reasonable person would rely upon, as the court knows, there was only one defendant when this lawsuit got filed, and that was this defendant. And every other defendant that was added because this defendant filed a non-party at fault several months in. In other words, the primary defendant, and we believe what a reasonable person would find, is that the primary person who created the condition was the landlord who's collecting all these rents, and doesn't say, was our primary breach issue from the complaint through disclosure, through discovery, and would be at trial if we had the opportunity. The fact that you didn't just say to your tenant, who you knew was a man who was in a position where he may really believe he's in trouble, and anyone has a right to protect their
Who
home.
react in a certain way.
This person more than most.
Yeah.
I mean, if someone shows up and they only pay you at night and they're always wearing black and they're in law enforcement, but they can't tell you and they have a bulletproof vest on, I think a reasonable person might say to themselves, perhaps this is an individual who may defend his home. And I'm not saying he didn't have a right to. And in fact, the police thought he had a right to, and the prosecutors thought he had a right to. In other words, no one ever charged or went after this individual in any way, including us. Nobody has. So I believe the duty, the trial court basically found, and given there was a lot of discussion, it was clear the trial court, this doesn't fall into any simple category. I recognize that. So this is not a criticism of the court, other than the fact that I think the trial court ended up getting this one wrong, because to say there's no duty says it doesn't matter if everything we say and more were true. There's simply no duty, even if you created the situation that could have been avoided. The breach
And if,
issues.
for example, the tenant, I mean, your point would be made if the facts were the tenant said, just let you know, if anyone comes in, I'm going to shoot him.
Then there's no duty.
Yeah. Okay.
There's no duty. In fact, if Mr. Ciccarelli had said to, if Mr. Harrison had said to Mr. Ciccarelli, I've waited my whole life for the opportunity to one day finally, after all these years, shoot somebody. But I wish someone would ever break into your house. It's a bad neighborhood. That's why I chose it. This is in no way suggesting it. My point is, Gibson has made clear that we're taking a step back on duty and saying, look, duty exists except for, and I realize that I wish the court had adopted Justice Hurwitz's opinion, which was even more open, but even as far as it went, it took a big step back to say, basically, duty unless there's a reason it's not. I'm overstating it, but there's a duty here. If there's a duty, it's clearly a question of fact on breach. And as to my other issues I was going to address, I'd rather reserve my last 2 minutes if I can. Thank you.
Thank you, counsel. Mr. Doan.
Your Honors, may it please the court, my name is Eddie Doman. I represent the appellees, the Ciccarelli defendants. I want to touch on the first point as it relates to the contract. if you look at the actual pleading that he referenced that's in the index of record on 104 through 108, you'll see that the bank was relying on it to say that it wasn't premature to send someone because they thought the property was abandoned. The entire paragraph is listed in their brief, but they only highlight C, which says that if you've abandoned the property, and then their entire argument in relation to this section deals with abandonment. And the reason I think they did that is because it is the law in Arizona that you do not have the right to possession of the property simply upon a default. Arizona follows the lien theory of mortgage law, and this is in our brief in the section regarding his potential status as a trespasser. And Arizona has also adopted the restatement of property as it relates to mortgages. Section 4.1b of that restatement section says that any agreement, whether in a mortgage or not, that grants the mortgagee as mortgagee the right to possession in the future is unenforceable except as provided in Section 3.1c, which deals with doing the statutory foreclosure and the right of redemption, if you look at 3.1c. And then it lists 3 exceptions. The only exception that would be relevant in this case is exception 2, which says the mortgagee enters after abandonment by the mortgagor. According to this section of a restatement, any provision in an agreement that gave the bank in this case the right to possession of the property absent abandonment would be void. And when you look at all of the testimony in this case, it further backs that up. The LPS people said they wouldn't have gone to the property if it was abandoned. They were going, before they hired Mr. Alkenbrack, to change the locks, to check on the property, to simply see if it was abandoned or if someone was living there. When they noted someone was living there, which happened 3 months or 3 weeks prior to this event occurring, they just simply mark that someone's there and they go about their business and then check later. There was also evidence in the record that the bank knew that there was a tenant there, that there was a note where someone had talked to someone on the phone. It's in our response to the...
Okay, well, that's whether there, knowledge is a question of fact. I'm intrigued by the duty, by your answer to the question, though, that although, what I hear you saying is, although the excerpt of the deed of trust that's in the record in that exhibit says that the lender or the trustee has the beneficiary has a right to come on, you're saying under Arizona law that's not enforceable.
Absolutely. I think the restatement applies. The restatement says it's void unless if you have abandonment. And another point that can be made as it relates to the provision, even if you want to read it strictly, it says they can do what's reasonable and necessary to protect their interest in the property. It's not reasonable and necessary to go change the locks on a house that's occupied and has a tenant in it to protect your interest in the property. That's completely unreasonable, even using the terms of the agreement that could apply if Section A worked.
Although there's a pretty good factual basis for what Mr. Alkenbrick did when he came on in terms of trying to discern whether it was occupied or not. So I don't know, reasonableness is the best.
Well, but when it relates to, okay, the bank's right to be on the property is based on whether or not the property is abandoned. Now, I believe what you're talking about is, was it reasonable for him to believe it's abandoned?
Well, yeah. That's,
I believe that that's a question of fact. And when we're talking into the nature of his relationship to the property, if the bank only has a right to be there if the property is abandoned, if he misbelieves that the property is not abandoned, that doesn't affect his status as a trespasser. There's Arizona law directly on point that says even if you honestly believe you have a right to be there, or even if you honestly believe that you had a right to be there by virtue of something that a possessor of the land or that you thought was the possessor of the land told you, that doesn't change your status as it relates to whether or not you're a licensee, an invitee, or a trespasser. And so any sort of factual mistake regarding whether or not the building was abandoned doesn't change the legal relationship of this property, and it doesn't change the bank's actual ability to be on the property to change the law. That mistake of fact, by virtue of the law as it relates to trespasser, can't change your status.
You said that Arizona has adopted the restatement of property, which of course it has in general. Is there a case in Arizona that's adopted that particular section of the restatement upon which you rely?
Your Honor, there is not a particular case that adopts Section 4.1. There's about 12 states that have done it. If you go through the shepherdizing process, Arizona is not one of them. But I would note that in addition to adopting the restatement of property generally, we all know Arizona has the general rule that absent law to the contrary, it follows the restatement. So I still believe that, absent a case to the contrary, even outside of their adoption of this provision, absent a case or something specific to the contrary, then this restatement provision obviously applies, and this restatement provision obviously says that any clause in this contract that gave them a right to possession is void absent actual abandonment. I'd like to touch briefly on the first point that we made in our brief about the right to appeal the judgment, period, as it relates to the concept that the plaintiff took advantage of this judgment by virtue of proceeding against LPS, and that it could also be barred by that doctrine, and the doctrine of res judicata and the doctrine of collateral estoppel.
Explain that. I didn't follow that. Your contention is that the plaintiff should have appealed the jury's finding against LPS, the verdict against LPS?
The final judgment in this case that had the percentages, it involved several non-parties, it involved LPS, it involved the plaintiff. As a matter of law, that final verdict, the calculation that they end up making, includes 0% against the bank and 0% against my clients, the Ciccarellis.
Well,
Now,
but it doesn't have any, it wouldn't have any effect on trial and remand, though.
Well, I think it does, which is why I think collateral estoppel applies. When you're speaking specifically of issue preclusion, I think res judicata applies because of claim preclusion, because of the idea that this jury verdict included by definition a previous finding as a matter of law that my clients had no fault. But at the very least, issue preclusion would apply to the extent that the jury attributed the fault for this accident and determined the total amount of damages. And those percentages of fault both become the law of the case and are relevant for collateral estoppel purposes. The plaintiff in his response says that collateral estoppel doesn't apply because we're dealing with the same case, but this court has routinely dealt with.
Well, no, I'm sorry, back up. What exactly is the finding of the jury that you say that you argue would apply to your client? That there was no fault attributed to your client?
Well, correct. They attributed all of the potential fault and awarded damages based on those percentages.
But that's because of the fact that the court granted summary judgment in your client's favor, and then appropriately, based on that law, didn't allow the jury to apportion any fault to your client. The jury didn't weigh the issue, didn't consider that issue, did it?
Well, right. And if you had a problem with the jury not being able to consider the issue in relation to applying the fault distribution amongst all of these multiple parties, your remedy is to appeal the entire verdict and request a trial whereby all of those particular defendants and my client could have been available for the comparative fault to be allocated.
Well, but on retrial, your client, I'm getting your accent when I'm asking the question. That's not right. On a retrial, do you think that anything that any apportionment of fault that the jury made in the first trial would bear on retrial? Isn't it a complete do-over?
Well, it can't be a complete do-over because this verdict has been satisfied. And so,
as to that portion.
Well, I understand, but it's not correct under the law to be able to have a jury verdict based on no fault here. And then, I mean, if what you're saying was to occur, we could go to a retrial and there could be 100% finding of fault and all of the damages, and then all of a sudden you have a jury verdict for all the damages in this case, and then a jury verdict for part of the damages in this case. And that result, those inconsistent verdicts, is exactly the reason why the doctrines of res judicata and collateral estoppel, or claim and issue preclusion, whichever way you want to refer to them, that's why those exist, to prevent that occurrence.
Who's hurt by the fact that there might be a do-over? I mean, I can see LPS objecting. LPS might say, hey, the jury laid off on us more fault because it wasn't given the opportunity to lay off fault on the Ciccarellis. But how are the Ciccarellis hurt?
Well, because they're not getting to attribute fault to these parties in the manner by which those parties' faults have already been fully adjudicated by the jury as the fact finder.
Well, they'd be non-parties at fault on remand, right?
Well, frankly, Your Honor, I do think the doctrines of collateral estoppel apply. I will say that if there is a remand, I think we should be limited to the plaintiff's percentage of fault that exists currently. I don't believe you can simply do it all over and then have this double recovery of the plaintiff. And again, it's my position that collateral estoppel is that the fault has already been determined, and if you had a problem with the idea that Ciccarelli's fault was not a part of that, your remedy was to appeal the whole verdict. LPS brought this up in its motion for a new trial, where it noted that the doctrines of comparative fault would apply, and that if the court was wrong, that we would have to have a retrial with everyone involved. And you know, at that time, the plaintiff is faced with a dilemma. You know, do I keep my verdict or do I retry it all? And in this case, he filed a pleading that said the trial court's decision was supported by Arizona law. I mean, amongst other things. And then, you know, on the eve of settlement, that ends up getting taken out of the pleading. But the truth is, that's the remedy if you have a problem with this. But by accepting the verdict as is, with all percentages of fault allocated and total damages decided, there is no more fault to attribute. And it would be unfair to allow that sort of windfall.
There's not a case on this in Arizona, is there? I couldn't find one.
There's not a case directly on point, but I will say that the court has routinely applied collateral estoppel in the same case before. You know, in principal agent situations, we know that collateral estoppel gets applied after a settlement with an agent goes through, and as you noted, and Judge Thuma joined, in that situation, when you have a consent issue, the only issue that you're dealing with is the collateral estoppel point, whether issue preclusion. And so you're looking at that prior judgment and saying, is there something about that judgment where an issue, all the issues in the case have been fully decided that requires something to happen? Well, in this case, we have a judgment on the merits, so we're dealing with both claim preclusion and issue preclusion. And that verdict was received by virtue of them getting the benefit of the 0% allocation to Ciccarelli. And all of the percentages of fault and all of the damages based on those percentages have already been decided. Which,
Do you think the amount of damages, I think the plaintiff is would be stopped on remand to contest the amount of damages found?
well, frankly, on remand, I believe if this court does remand it, which I hope they don't, we would deal with a deal where it would be our client's option. You could either invoke the doctrine of collateral estoppel to set the damages at that level, or since you weren't a party that was there with the opportunity to defend that claim, you could insist that the damages be retried. And so that's the way it would work on remand, because we're dealing with defensive collateral estoppel.
Yeah.
But I do think those doctrines apply when there's a decision in the same case, for the reason that the court has routinely done it.
What's odd about this is, I mean, what's made this issue is that the court didn't allow the jury to attribute fault to a party that it had granted summary judgment to.
Right, and I think that's appropriate. I do think that was the right decision. Although, again, one of the things they said in their brief is that this was a divisible issue, and that's a position that was totally contrary to what they said in their objection to Rule 54B language. Because, again, if you had a problem with the summary judgment motion, you allowed the 54B language, this issue could have come to this court, it could have been decided, and then the trial in the underlying case could have taken place. At that time, when we were dealing with Rule 54B, they said, and it's Index of Record 173, the plaintiff said, quote, "It could not reasonably be argued that the issues were not very closely tied to one another between the dismissed defendants and the remaining defendant LPS. In fact, the arguments and factual underpinnings are basically identical as to all three defendants." You know, so they're taking the position that it's not, you know, divisible, and now we're coming in and saying, well, it is divisible, so these doctrines, you know, shouldn't apply. The truth is, it's the law of the case that it wasn't a divisible issue. And at that point, your remedy upon the verdict is to appeal the entire verdict and have a retrial where you're also attributing fault to Ciccarelli. Your option is to either do that or have the verdict that you currently have. I think that is completely fair. If you really want to have Ciccarelli's fault allocated, well, then you can just appeal the entire verdict based on the court's summary judgment motion. There's nothing wrong with that being the plaintiff's option from a fairness standpoint to decide what they want. For that to be the case here, and for the other case to be that collateral estoppel and res judicata principles or the concept of taking advantage of a verdict precludes you from trying to do both options, to take the verdict and not appeal the fact that you didn't get to attribute fault to Ciccarelli, to take that verdict and satisfy it, and then get another windfall over here by only going against Ciccarelli. That's where the fairness comes in and why this result is appropriate. As it relates to Gibson, since we talked about duty, after the Gibson case was decided, this court specifically noted that the relationship of the parties was still relevant. In Vasquez versus State, the court said, Gibson's clarifying gloss on duty issues did not alter the well-established principle that in order for a duty to exist, the relationship of the parties must be such that the defendant is under an obligation to use some care to avoid or prevent injury to the plaintiff. After Gibson, this court said you have to look at the relationship of the parties. So determining whether or not we have an invitee, licensee, or trespasser in this case is still important. It is still relevant. And it is why there's no liability here. This court has never abrogated the difference between nonfeasance and misfeasance. And it's an incredible stretch of logic to say that the allegation here that we did not inform someone that a tenant existed is anything other than nonfeasance. Misfeasance is clearly when you actively do something and there's a claim based on your action. Nonfeasance is clearly when you fail to do something. And no action for nonfeasance stems absent a special relationship, which doesn't exist here, based on the relationship of the parties.
And that follows from the legal conclusion that you would advocate that because the lender had no right to come onto the property, that the plaintiff was a trespasser. And as a matter of law, under the duty under the relationship construct, your client had no duty to him as because he was a trespasser.
Well, correct, and I think the same result attaches if you say he's a licensee. I think at best what we're dealing with is a licensee, because there's a section of the restatement that says that if you're on property by virtue of a private purpose, you're a licensee. Keep in mind that this is your action against a possessor of land. If you're there for a private privilege, you're a licensee. Because we're a lien state, there's no question the bank doesn't have possession of the land. That's unequivocal. And so we're dealing with your rights against who is the actual possessor, which in this case, until the actual transfer of land by virtue of the sale, is unquestionably Mr. Ciccarelli through his lease, the tenant, Mr. Harrison. And so even if he had a right to be there, let's say the bank did have a right to be there, he had a right to be there as a licensee, a person who, not the possessor of the land, but someone else has a private privilege, the ability to go on the property to change the locks. In that case, he would only be a licensee. And Arizona has recognized that you don't have a duty to protect licensees from attacks by a third party. The Parrish case dealt with the facts where someone has a social guest at their house, he opens the door, a guy comes in and shoots. And the allegation was you shouldn't have opened the door. You caused me harm. And the court says, no, you're a licensee. There is no duty. No liability can attach.
Well, aren't there issues even before you get there because the Ciccarellis weren't in possession of the property themselves. They were landlords. And I searched the briefs for any instruction on the duty of a landlord not in possession to even an invitee.
I don't believe there's a single case in the history of American jurisprudence that has ever held that a landlord has a duty to a third party to inform his tenant of a foreclosure. Leases and mortgages have existed in the United States since the 1700s. You can read cases from Pennsylvania and Virginia that even predate 1776. I've searched long and hard for a case that has ever held that a landlord owes a duty to a third party for informing his tenant that there's a foreclosure, and I don't believe one exists. Because if a duty, even if it did exist, would be for, as the court found in its order granting summary judgment, it would only exist for the benefit of the tenant to know about the situation in his land, to find other premises. It would not extend to third parties. No court ever has ever held that. That's all my time. Thank you.
Thank you, counsel. Mr. Breyer.
Last point first, Piccola versus Woodall makes it clear, as does a long line of cases we cite, a landlord has the opportunity to has the obligation to let his tenant know of any unreasonable defects on the land, or in other words, the tenant, it's the landlord that didn't tell his tenant, which is what created the situation. But let's take a step back to address this. Number one, the simple question here is there a duty to a landlord that knows of a potentially dangerous situation to someone who may come on his land and doesn't pay the mortgage, one, doesn't tell the person, they're arguing, well, you don't have a right to come on until it's abandoned. Everybody, the bank, LPS, my client, thought it was abandoned because this landlord, the defendant, failed to let them know it was not abandoned in spite of their efforts. So number one. Number two, the restatement that's being cited is not the restatement. The restatement they actually talk about, when there was an argument just now that, even mistake is not okay, that's the restatement of torts for trespass to land that is in fact a strict liability tort. That has nothing to do. This is not a strict liability situation. So all of that language about the fact that you're not excused for mistake, that is in the unusual strict liability tort setting that was cited perhaps mistakenly in the brief, not this case. We're talking about fairness to this particular defendant. This defendant's argument is that my client, when he lost the opportunity to pursue the primary defendant, was not allowed to go forward with trial and then not satisfy the judgment. It was a notice of settlement. Settle out with the other clients.
What's the answer to the argument that even though the deed of trust may have authorized the lender to come on the property, Arizona law would have trumped that?
Perhaps it would, but what Arizona law? The restatement that they cite says, and I'd have to
Property
grab
12.1.
That's right. But first of all, it hasn't been adopted. Second, what it talks about is no right to possess, and here what we're talking about is going on to a property you believe is abandoned to begin the process of changing out the locks. So at that point, you don't have possession. Now, I don't know if the restatement has significant discussion about the difference between possess versus to protect the property, because this talks about the right to secure the property as opposed to actually move in and possess it. I don't know, because the restatement has never been adopted by this state. It has not been alluded to anywhere, and it really isn't what that restatement section is about. And I would be surprised if there's a restatement or any law anywhere that says the thousands of banks that were doing, or thousands of mortgages that were in foreclosure that were having exactly this happen, that these were all somehow trespassers as opposed to business invitees, which I obviously do not have the opportunity to address. Thank you, and I'm sorry for the speed talking at the end.
Thank you, counsel. Counsel, we appreciate your briefs. We appreciate your argument today. We will take this matter under advisement. We'll issue a written ruling in due course. Thank you all.
Thank you.